As a result of the numerous challenges to his attempt to limit birthright citizenship by executive order, it now looks like the justices are siding with Trump on something, but not the thing he actually needs. What they appear to be agreeing with is the idea of restricting judges' power to issue nationwide blocks, not endorsing Trump's effort to cut back birthright citizenship itself. On the constitutional question, they haven't ruled one way or the other. Instead, they're narrowing the authority judges have to freeze policies across the entire country. Now, here's what's remarkable, and it shows that the courts are still drawing a firm line against Trump's most extreme constitutional overreaches even when the Supreme Court tries handing him a partial win. Even after the Supreme Court ruled 6-3 in Trump v. Casa to limit nationwide injunctions, every lower court reviewing Trump's executive order eliminating birthright citizenship has reaffirmed its block. The Ninth Circuit said the order is plainly unconstitutional and kept the injunctions intact. For district courts and multiple appellate panels have now formed a unified judicial wall that's stopping Trump's attempt to rewrite the Constitution through executive action. But before we move on, look, mainstream media just isn't reliable anymore. That's exactly why we created Pump Politics, to give you real reporting, meaningful context, and zero corporate spin. If you want to stay ahead of the news cycle, jump on our free newsletter. We'll send you the important stories straight to your inbox daily. Click the link in the description to join. And if you just want to support what we're building, join the community that still cares about the truth. Now let's get back to the video. Let me lay out what actually happened, because the legal dynamics here are fascinating and they show the limits of even a Supreme Court ruling that appears favorable on the surface when the underlying executive action is this blatantly illegal. In June 2025, the Supreme Court ruled 6-3 that lower courts had been too liberal in handing out nationwide injunctions that blocked federal policies everywhere instead of only protecting the plaintiffs in front of them. This gave Trump a procedural win that was supposed to reduce the power of single district judges to shut down federal actions nationwide. Trump's team treated the ruling like it was a major breakthrough, something that would allow them to enforce the birthright citizenship order. Their theory was, even if some courts blocked the order for specific plaintiffs, it could still take effect in the rest of the country. States that didn't sue or were in more favorable circuits might see the order enacted, creating a patchwork where birthright citizenship existed in some states but not others. But here's what actually happened. The lower courts looked at the Supreme Court's ruling, acknowledged the new limits, and then blocked the executive order anyway. In July 2025, the Ninth Circuit unanimously ruled that Executive Order 14160 violates the 14th Amendment's Citizenship Clause and upheld the injunctions within its jurisdiction. Other circuits followed exactly the same pattern. The Supreme Court's decision adjusted the scope of injunctions but didn't touch the core constitutional issue, and on that issue, every single court has found the order unconstitutional. Think about what that means. The administration managed to get a favorable ruling from the Supreme Court on nationwide injunctions, and it changed nothing. Lower courts complied with the procedural adjustments and still blocked the order. The constitutional flaw in Trump's attempt to redefine the 14th Amendment is so fundamental that procedural tweaks don't fix anything. The result? A bizarre patchwork that exposes just how absurd this entire strategy was. In states where lawsuits were filed, Washington, New Hampshire, Maryland, Massachusetts, and others covered by the appellate rulings, birthright citizenship functions exactly as it has for 157 years. In theory, states without active litigation might see the order take effect, creating a citizenship lottery depending on where a child is born. But even that limited application is legally shaky because the constitutional violation doesn't change from state to state. The administration's legal argument that the 14th Amendment's birthright citizenship provision applied only to freed slaves and not to children of undocumented immigrants has been rejected by every court that's reviewed it. Judges appointed by Democratic and Republican presidents alike have called the interpretation contrary to the Constitution's text, to Wong Kim Ark from 1898, and to over a century of settled practice. The administration cannot find a single federal judge who supports their reading of the amendment. This unified judicial stance across 4 district courts, the First Circuit, and the Ninth Circuit sends a clear message about the limits of executive authority. Trump can sign whatever executive orders he wants and claim whatever constitutional interpretation suits him, but when every court rejects it unanimously, the claims have no legal weight. The judiciary is functioning exactly as the Constitution intended, as a barrier against presidential overreach. And the Supreme Court's choice not to address the merits speaks volumes. The 6-3 ruling dealt only with the injunction issue, not with the constitutionality of the executive order. The justices deliberately left the merits for the lower courts, and the lower courts have now effectively resolved the issue by unanimous rejection. There's no circuit split, no real legal disagreement, no plausible path for the administration to win. The order is essentially dead. It's just a matter of how long the administration wants to keep appealing for show. This connects to the broader pattern of courtroom losses we've been covering throughout Trump's presidency. The troop deployment cases? Blocked. The immigration enforcement expansions? Blocked. The agency restructuring? Blocked. And now birthright citizenship is blocked even after a Supreme Court ruling the administration celebrated. Trump keeps pushing the limits of executive authority, and courts keep pushing back. The system is strained, but it's functioning. So in this video, we're breaking down what the Supreme Court actually ruled and why it didn't save Trump's birthright citizenship order, how the lower courts responded, and why this united judicial resistance matters. We're also unpacking the bizarre patchwork implications and why even that doesn't give Trump what he wanted. A federal court in New Hampshire blocked President Trump's birthright citizenship order after a nationwide class action lawsuit was filed in late June. So let's bring in CBS News Justice correspondent Scott McFarland. What's the significance of this ruling? It's a major statement following the Supreme Court's landmark decision limiting single judges from issuing nationwide injunctions. And we're going to talk about what all this tells us regarding the durability of constitutional limits in the face of executive overreach. Now let's get into the specific legal mechanics of what the Supreme Court actually decided. The court's June 27, 2025 ruling in Trump v. Casa addressed a procedural question that's been debated for years: should district judges be able to block federal policy nationwide, or should they only be protecting the plaintiffs in their cases? Conservatives and the Trump administration argued that nationwide injunctions give individual judges too much power, letting any one of over 600 district judges halt nationwide policy. The 6-3 ruling sided with that argument and set limits on the scope of injunctions. But the ruling had important boundaries that became obvious once lower courts began applying it to the birthright citizenship cases. First, the Supreme Court deliberately avoided ruling on the constitutionality of the birthright citizenship order. The opinion focused exclusively on injunctions and left the substantive issue to the appellate courts. And on that question, the lower courts are unanimous: the order is unconstitutional. Second, the ruling still permits injunctions protecting the plaintiffs in each case. And in these cases, the plaintiffs include states like Washington, plus immigrant rights organizations and families whose children would be affected. That means large parts of the country are still covered. Third, the ruling acknowledges that in rare cases, broader relief might still be appropriate if the constitutional violation is glaring or limited relief would cause chaos. Some courts have cited this narrow exception in maintaining wider blocks. The Ninth Circuit's July 2025 ruling is the most important post-Casa decision. The panel unanimously held that Executive Order 14160 violates the 14th Amendment and upheld the injunctions in its jurisdiction. Their reasoning echoed what other courts found. The 14th Amendment's language is unambiguous, subject to the jurisdiction just means being governed by U.S. law, not immigration status, and Wong Kim Ark definitively settled this question more than a century ago. The First Circuit reached the same conclusion earlier. No appellate court has found any validity in the administration's interpretation. This patchwork enforcement problem, created by the Supreme Court's procedural limits, highlights the absurdity of the administration's strategy. Birthright citizenship continues in states with injunctions, and in theory the order could take effect elsewhere. But that outcome would produce a citizenship lottery that contradicts the entire purpose of the 14th Amendment, which establishes a uniform national standard. The practical implementation issues are massive. State and local officials issuing birth certificates would have to check parents' immigration status, something they don't currently do. Hospitals, vital records offices, state agencies, the Social Security Administration, and passport offices would face logistical and legal chaos. These real-world problems only worsen the constitutional ones, and lower courts have cited both. The administration's decision to keep litigating despite unanimous rejection is political, not legal. There's no plausible path to victory, but continuing the fight lets them say they're pushing their agenda while blaming activist judges for stopping it. The Supreme Court is unlikely to take up the merits because there's no circuit split, a key factor in whether the court grants review. So let's break this down into the essential takeaways that everyone needs to understand. Point 1. Even after the Supreme Court's ruling reducing the power of nationwide injunctions, lower courts have still unanimously blocked Executive Order 14160 as unconstitutional under the 14th Amendment. Point 2. The Supreme Court intentionally avoided the merits, and every lower court has said the order violates the Constitution, Wong Kim Ark, and over a century of practice. Point 3. There is a unified judicial front with zero dissent. No judge has accepted the administration's interpretation. Point 4. The patchwork enforcement situation creates a citizenship lottery and logistical chaos. Point 5. The administration's ongoing litigation is political theater, not a real legal strategy. The Ninth Circuit's ruling is especially significant since it covers 9 western states including California, which has the largest immigrant population. Upholding the injunction there ensures birthright citizenship continues normally for millions. The Supreme Court's ruling narrowed nationwide injunctions, but when a policy is unconstitutional, limiting injunction scope doesn't make the policy constitutional. The executive order remains illegal no matter how many states it technically could apply to. The logistical impossibilities further undercut the order. Verifying parents' status at birth, handling mixed-status families, updating vital records, and so on. The 14th Amendment defines national citizenship, not state-specific citizenship rules. Creating state-by-state differences violates the entire purpose of the amendment. Politically, this united judicial rejection could be significant going into 2026. Democrats can cite it as proof Trump disregards constitutional limits. Republicans face pressure over whether they support attempts to rewrite constitutional amendments through executive action. The pattern of legal defeats across multiple policy areas reinforces the image of an administration constantly exceeding legal boundaries and constantly being checked. The judiciary's resistance is reassuring, even as the extremity of the policies being checked isn't. The system's checks and balances are holding. The administration's strategy of attacking judges loses credibility when every judge rules the same way. At some point, unanimous rejection becomes its own evidence. The Supreme Court's avoidance of the merits likely signals they see no need to intervene when the lower courts already agree unanimously. There's no split to resolve. This episode shows both the danger and the safeguard in our system. A president trying to rewrite a constitutional amendment through executive order, and courts across the country refusing to let him. The Constitution held. Looking ahead, the administration will probably keep appealing, even knowing the outcome won't change. The Supreme Court will probably avoid the merits. Birthright citizenship will continue as it has since 1868. Trump's attempt to change it through executive order has failed entirely. That's where things stand. A unified judicial resistance blocking Trump's order even after the Supreme Court's procedural ruling, the Ninth Circuit's unanimous finding, the patchwork enforcement absurdity, the lack of any genuine legal disagreement, and the continuing pattern of courtroom defeats that keeps checking this administration's constitutional overreach. Stay subscribed, because the litigation will continue moving through the courts. The administration will keep appealing. The Supreme Court may or may not weigh in. The patchwork issues might cause real problems. And this could become a major 2026 campaign issue. But if you think courts will eventually stop blocking Trump's unconstitutional orders, just look at the unity of their rulings so far. They're holding the line, and all signs suggest they'll keep doing so. I'll see you in the next one.